Well, at least I found the building, and I didn't have to park too far away this time. I'll bet their offices are all the way at the top. They usually are. It's these lawyers.
John Carson is a district traffic engineer. There's been a lawsuit filed, and he is on his way to give a deposition. He is not overjoyed. John knows that the setting for his deposition will probably be a conference room, and that the attorneys asking him questions will be more relaxed and informal than they would be in a courtroom. But he also knows that the testimony he gives in his deposition is just as serious and important as if he were testifying in court.
If I can remember everything that lawyer told me, I should be all right. What was his name again? Mark, that was it. I hope he's already here.
With you at the deposition will be an attorney from the Commonwealth, either from the Attorney General's office or the Department's Office of Chief Counsel. The attorney who called for the deposition will, of course, be there, and if the lawsuit also involves other parties, there will be an attorney there for each of the other parties involved in the lawsuit. And there will also be a court reporter, making a record of everything that's said. Each of the attorneys present at the deposition will have the opportunity to ask you questions, and because the setting is less formal than the courtroom, they can ask you just about anything without your attorney objecting.
Directly in the chain of command.
Although the deposition may drag on, the less formal setting allows you some freedom you don't have in the courtroom. If you need a break, you can take one.
Sure, sure. Excuse me.
The purpose of a deposition is twofold. The principal purpose is to gather information and make a record of what facts you know that might be important to the lawsuit. This can help the attorneys evaluate the case and possibly settle it without going to trial. But how you behave in a deposition can also show an attorney how strong or weak a witness you'll be if the case does go to trial. That's why it's important for you to react to and answer the questions in your deposition just as you would in front of a judge and a jury. Let's consider some of the things you should and shouldn't do. At a deposition, it's not going to matter if a question is irrelevant, and you may find that the attorneys will ask the same question several times in several different ways to try to get the answer they want. Or the attorney may just not understand what you're telling him. This, plus your own nervousness, can make the process uncomfortable and tedious.
Now, Mr. Carson, you're saying that traffic could safely travel this stretch of highway at 55 miles an hour, isn't that right?
No, not exactly. There was an advisory speed posting of 35 miles an hour on the southbound lanes, and the northbound lanes had no advisory speed posting, but there were curve warning signs on the approach.
So you're not disagreeing that traffic could safely negotiate this area at 55 miles an hour?
This guy is just not listening to me. It's exactly what I didn't say. I just told him there's a 35-mile-an-hour advisory posting.
Don't get angry or argue with the attorney. No matter how uncomfortable or frustrated you are with him or her, always treat the attorney with courtesy and respect.
No, sir. The advisory 35-mile-an-hour speed limit sign was posted for the southbound traffic. That indicates that southbound traffic should take the curve at 35 miles an hour, not 55.
Different attorneys have differing styles. Some may be aggressive and formal, others may talk to you like an old friend. No matter what the attorney's approach, your response should be neither hostile nor overly friendly, but matter-of-fact and polite. Answer all the questions calmly, simply, and truthfully, and don't try to be evasive or clever. And don't volunteer information that was not asked for in the attorney's question.
Mr. Carson, does the Department of Transportation save traffic counts for this particular segment of highway?
Yes, we have traffic counts for this segment. The average daily traffic was counted to be 9,800 vehicles. That count was part of a safety improvement study the department conducted about a year ago on a 4-mile stretch of highway. It included this segment. We did a couple of things on that safety improvement study, which included looking at the sight distance at all the intersections. We looked at the under-super elevated curves like the one we're talking about on this section of highway. And we took a detailed traffic count which was, I think, 9,850 vehicles, of which there were 23% trucks, which is pretty high for this section of road.
That's not what he asked you.
All the attorney asked was, did the department have a traffic count for this segment of highway? He didn't ask about a safety improvement study, or about the design of the curves, or the percentage of trucks. John volunteered all this information. When your answer is complete, stop talking.
The average daily traffic was counted to be 9,800 vehicles.
The attorney asking the questions may pause as though he or she expects more of an answer, and you may be tempted, like John was, to volunteer additional information just to fill the silence. Don't. Don't try to guess what information the attorney wants to hear. If the attorney isn't satisfied with your answer, a follow-up question can be asked. Volunteering can lead into damaging areas the attorney may not have gotten into. You can see how John's attorney feels about his answer.
Okay, Mr. Carson, now you just spoke about the traffic count on this particular section
Yes,
of
we
highway.
took that as part of the,
I'll start again. Mr. Carson, you talked about the traffic count.
Be sure you understand what's being asked before you answer. Don't interrupt the question because you think you know what the question is leading up to. And if you don't understand a question, don't try to answer it.
segments of this highway.
When the department takes a traffic count, does the sample size result in a standard deviation and chi-square value that meet the criteria for statistical significance?
Yeah, I'm sorry. I took statistics courses while I was in college, but I don't remember the terms exactly anymore. Could you ask me that in some other way?
Well, let me put it this way. How do you know that your traffic count accurately represents how much traffic, and in particular what percentage of truck traffic, is actually using that highway on a daily basis?
Once you understand the question, stop and think. Formulate the answer in your mind before you speak.
Our traffic counting equipment is like that's used and approved for use in the transportation industry generally. So as a result, we operate that the same as any other Department of Transportation might. In fact, the machines are calibrated and checked on a regular basis in accordance with AASHTO standards.
Listen carefully to each question and answer each question thoughtfully. If you don't know the answer to a question, don't guess or give an answer you think might be correct. Say you don't know.
Well, I don't know them exactly.
If,
They're
after the
published.
deposition, you find out the correct answer and you're asked that question in court, you'll have to explain why you're giving a different answer than you gave in your deposition. This could make you appear less believable to the jury. Avoid characterizing an answer with honestly or truthfully. This could give the impression that some of your other answers were not honest or truthful. And avoid absolutes like never and always. The subpoena for the deposition may require you to bring documents with you, or you may want to take your file along to help you answer the attorney's questions. Always briefly review what's in the file with the attorney who's going to be with you at the deposition, if you can, to familiarize yourself with the documents. The documents in the file may contain information you would not have remembered or might have remembered differently without reviewing them. Of course, anything you bring with you to the deposition, either because you were required to by the subpoena or to help you remember, is available to the other attorneys to review. No one is ever completely at ease while giving a deposition, nor should they be. The court reporter is taking everything down, and what you say and how you say it can be very important. Just listen to each question carefully. Make sure you understand it. Then, if you can answer the question from what you know or what you can remember with the help of your files, answer it simply and truthfully. If you can't answer a question or don't understand it, say so. And once you've given a complete and correct answer, stop talking. Now let's look at some of the kinds of questions an attorney might use to get you to say something you don't really mean, or to give an answer that isn't really correct or complete. A lot of the questions you are asked may be leading questions. A leading question states a fact and asks you to answer either yes or no, or to agree with the statement the attorney has made in the question.
Ms. Hall, you indicated that you are the Assistant County Maintenance Manager in Tioga County, is that right?
Yes,
And were you so employed as the Assistant County Maintenance Manager in Tioga County in 1988?
yes,
And isn't it true that you were required to drive the state highways within Tioga County on a once-per-week basis back in 1988?
yes. Well, no, not all the roads in Tioga County, just in the area assigned to me. And not once a week precisely, but about once a week.
Listen to the question carefully, and if the fact the attorney stated in his question isn't entirely correct, not just more or less correct, don't answer yes. Give an accurate answer. Just because the question seems to want a yes or no answer doesn't mean you can't say anything else. Another kind of question to be careful of is the compound question, one that actually asks two or more questions but appears easy to answer with a single yes or no.
So it's your responsibility, Ms. Hall, to travel this roadway once a week to see if all the signs are up. And if the speed advisory plate had been missing, you'd put it in order to have it replaced. And within a day or two, a sign crew would go out and replace the sign with a new speed advisory plate. Is that correct?
The answer to part of the question, or even most of it, may be yes, but the answer to another part might be no. To answer, break the question down into its parts and answer
as I said
each part
before,
separately.
I ride the roads in my area about once a week, but I'm not just looking at the signs every time. One time I might be looking at the shoulders, checking for drop-offs. I may be looking at the road surface, checking for potholes, or I may be just concentrating on signs. It's impossible to look at everything at once, just riding down the road. But no matter what I was concentrating on, if I did notice the speed advisory plate was missing, I would notify my sign foreman and have him replace it. Normally, we have those signs on hand in the county, so it would be replaced within a day or two.
Sometimes an attorney will ask a very broad question.
If you were the construction inspector on this job, please tell me all about the procedures that the contractor followed in curing the concrete on the bridge deck.
These tell-me-all questions can be a problem. Even in a less stressful situation, it's difficult to remember everything. In the anxiety of having your deposition taken, you might easily forget to include something in your answer. Later, if you're called to testify at trial and you try to expand your answer when you're asked the same question, you'll be asked how come you remember more now than at your deposition, and your truthfulness will be called into question. Qualify your answer.
Of course, it's difficult to remember everything from this project. I may have forgotten something, but from what I remember, that's all that was done.
Sometimes an attorney will follow a series of questions with one summarizing the many answers you've just given and ask if basically that's what you said.
Well, let me just summarize what you've told us, Mr. King. You've been assigned foreman in Tioga County for the past 5 years, and you've never replaced the speed advisory plate or any of the chevron signs along this stretch of highway. When you do have to replace the sign, it usually takes between 3 days and 2 weeks before you can do all the paperwork and get a crew out there to put the sign back up. Is that correct?
Listen carefully to the attorney's summary. Don't be too quick to agree that you've said what he says you've said.
Well, let me just summarize what you've told us, Mr. King. You've been assigned foreman in Tioga...
Correct any mischaracterizations of what you've said and use the opportunity to clarify anything you may have said that was vague or misleading.
Well, I don't remember exactly everything that I said, but I didn't say that it usually takes 3 days to 2 weeks to replace a sign. Depending on whether the type of sign was one that we had in stock, it could take up to 2 weeks if a new sign had to be made. Usually, signs can be replaced within just a couple of days.
If the attorney's summary seems accurate, answer with,
I don't remember exactly everything I've said, but your summary sounds about right.
not every question will be a trick question, and many attorneys don't use the tactics that we've just seen at all. What's important to remember is to listen to the question carefully and give an answer that you know is correct. Don't just agree with what the attorney has stated in his question. Everything is being taken down by the court reporter. It's up to you to make sure that the record reflects what you mean to say. A deposition is not something to be fearful of, but it is an important part of the legal process and can't be taken lightly. Remember, you're there so that the parties can discover what you know about the case. That's why everything is being taken down by the court reporter. What you say and how you say it are important. Listen to each question carefully and make sure you understand it. If you can answer the question from what you know or what you can remember with the help of your files, answer it simply and truthfully. If you don't understand a question or can't answer it, say so.
I don't know.
When you've given what you consider to be a complete answer, don't say any more. And there shouldn't be any reason for you to get angry or unprofessional, no matter what an attorney asks you. Remember that a lot of the questions will be leading and designed to simply get you to agree with the facts as they are stated by the questioning attorney. Listen carefully and make sure that your answers state what you mean to say. If you keep in mind everything that you've learned here, you should be able to avoid the major pitfalls encountered while giving a deposition. Remember, it's not just an ordinary conversation. This is a conversation. This is not. This is a conversation. This is not. This may have looked and even sounded like a conversation, but it wasn't. It was a deposition, and it's all recorded right here.